Good afternoon, everybody. Welcome to Common Scenarios Triggering False Claims Act Violations. This is part three, the final part of our three-part series. And today we're going to be addressing claims and investigations. I am Matt Feinberg. If you listen to any of these other webinars, you've probably recognized my voice. I'm joined today by my colleague, Mark Rosenau, who is my colleague both in the litigation and dispute resolution and False Claims Act practice groups. We are going to give you some examples today of the types of claims that can be filed under the False Claims Act and what we think you can do to prepare in the event of a False Claims Act violation and to respond when a claim or investigation is initiated. There's a little bit about me, you've probably seen it before, and a little bit about Mark. I'll give Mark a chance to introduce himself, and he can take it from here.
Great. Nice to meet everybody here virtually. There's my background and bio. Obviously, it's available on the website as well. Been with the firm for about a year working with Matt on these issues, and it comes up more often than you think. So I'm very heartened to know that everybody's joining us here, because the right time to be having this conversation is not in response to the government knocking on your door, but before that happens, and hopefully never happens. But if it does, you're going to be well equipped having listened to this webinar.
Great, that's a great point. We should have had a slide right off the bat on that. So a little disclaimer on the front end. This webinar is not providing you legal advice, and we are not creating an attorney-client relationship simply by you attending and us presenting this webinar. The scenarios we talk about may not fit your specific scenario if you are facing an FCA investigation. And so we encourage you, if you are or have specific questions about circumstances, that you should reach out to us. Our email addresses were on the prior slides, but they're also at the end of the presentation, and you'll be able to reach out to us either by phone or email and talk about your specifics. But please do not apply the general things we say in this webinar specific to your situation without thinking and talking to us before, because it may not always apply. So let's start with a little bit of an overview about what we're going to talk about today. If you've attended my False Claims Act webinars in the past, we're going to go over very briefly at a very high level, what is the False Claims Act and what types of FCA claims and investigations are possible. We're then going to get into some strategies for avoiding FCA claims and investigations, and then some strategies for responding to FCA claims and investigations after they've started. As Mark mentioned, the best time to have the conversation about the FCA is before you run into a problem, so that you either have the chance to fix it or the chance to avoid it from happening to you. But obviously, I wouldn't be in business if I didn't have the opportunity to help people get out of their FCA claims and investigations in the best possible way for the individual circumstances. Sometimes that's a settlement, sometimes that's a dismissal, sometimes that's a negotiated resolution with the government, but there's a lot of ways to get out of an FCA claim, and we'll talk about some of them today.
Thank you, Matt. This slide starts in 1863, but I still am going to get off of it in a minute or so. It is exactly as cast there in the first bullet. The False Claims Act is the primary vehicle for combating fraud. It comes out of the Civil War, and it was intentioned in the same way to combat rampant fraud from contractors back then. Some people might refer to it as Lincoln's Law. We've got definitions up here just so that we're ensuring that as we're having this conversation with you today, we're using some similar terms and understandable terms. So when we talk about claims, it's a request for money or property, exactly like cast there in the parenthetical, like an invoice. This can be a request for money or property that's sent directly to the government, or it could be sent to third parties for monies provided, either partially or wholly by the government by way of that third party. False is false. We understand what that is. These last two bullets are important, right? Everybody makes mistakes, and the error is human. So not all incorrect claims, which is different than a false claim, or violations of the False Claims Act. There's things like simple negligence, where it would be a failure to exercise due care, not necessarily getting you into false claims land. Now, with respect to knowledge and recklessness, again, this is separating the criminal, not criminal, I shouldn't say that, but the culpable mens rea from that would not be culpable. Knowledge has two parts. You can think about somebody having actual knowledge, like they actually understand that they're making the false representation to the government for this claim, or it could be a deliberate ignorance where they deliberately avoided having or holding that knowledge, and then recklessness as well. Just as a kind of table setting here, when we talk about it being the primary vehicle map, the numbers that I looked at this morning was something like $75 billion in recovery since 1986, where the FCA was renewed in terms of focus. And then just in fiscal year 2023, 2.68 billion in recoveries by the government, and about 2.3 billion of those from key TAM actions, which we're going to talk about.
Right, and every January or February, I do a webinar on the annual report that comes out from DOJ. And if I recall correctly, it'll be the last 3 fiscal years, so 21, 22, 23. There's a total of about 10 billion, a little more than 10 billion recovered by DOJ under the umbrella of fraud and the False Claims Act. So pretty high stakes we're talking about.
And here's the ways that False Claim Act violation might come through. Here's the definitions again. So we're table setting and everybody's talking about the same things, particularly if we have questions at the end. So if you do have any questions within the context that Matt provided in this non-representative setting, we would like to answer those as best we can. So false claim is precisely what you would expect a claim for payment or approval that's presented or caused to be presented to the government. That's easy. But you can also get into false claim concerns with false records or false statements where you make, use, or cause to be made or used a false record that's material to a false claim. That could happen through an express certification where along with an invoice you say, hey, I've met all the contract requirements, or an implied certification. An easy example would be, well, we negotiated a contract. The contract says everything that you always do is going to be within this setting and it's going to meet these standards. And then nobody talks about it when you're filing the invoice, but a condition precedent to you filing that invoice is that you had met that implied certification requirement. So you could get a false claim violation there too. And the reason I point that out, and I think Matt and I fixate on it in this presentation, is because the number of incidents ends up being very important in terms of estimating and calculating exposure. Where false claim would be where it's unlawful for you to knowingly conceal, avoid, or decrease an obligation to pay the government. This would be, in a prototypical example, failing to return identified overpayments that you found in an accounting inside your business to the government. So that would be a pretty easy example of how you might have a reverse false claim. So just asking for the money, it's not giving the money back when you should. And then conspiracy is precisely what you would expect, where there's a meeting of two minds at least, and an act in furtherance of that conspiracy to accomplish these types of violations. So we're going quickly through this, but we want to make sure that you guys are able to ask the questions with the same kind of language we're using, if you're inclined to do so.
Yeah, and when we talk about conspiracy, the thing that I like to remind people is that a prime contractor can have the absolute best intentions to submit a proper invoice. They've double checked all of their line items, their profit margins, whatever the fee they're applying, their indirect costs, their direct costs, and they're providing everything within their possible power to get it right with the government. But then the subcontractor submits an invoice to the prime, and the prime attaches the invoice and adds the cost without giving that same level of inspection or due diligence to the subcontract. If the subcontractor is intentionally misrepresenting the invoice in order to sort of maybe gild the lily a little bit and get a little more money on the contract, and the prime contractor isn't looking, that's the kind of thing that might get you one of those deliberate indifference violations. Now, if the prime is asking for backup, probably you're going to be insulated from liability on that subcontract. But the thing to remember is that liability travels up the chain, not down. So the subcontractor makes let's say a third tier subcontractor makes a misrepresentation in their invoice, they pass it up to the second, they pass it up to the first, they pass it up to the prime. All of those parties in the chain could potentially be liable for an intentional misrepresentation or material misrepresentation that justifies the False Claims Act. So things to think about. Blind trust is not usually a defense to the False Claims Act.
Thank you, Matt. And this, for our purposes, can be thought of as a negative incentive slide where we talk about where your exposure might be. There is significant exposure if the government comes looking at you for a potential False Claims Act violation. The measure of damages they look into that mandatory damages component is typically going to be calculated bespoke to your circumstance. It's very hard to generalize. That's why we have a couple of examples up here. But as a general idea, it's the difference between the value of what the government received as against the value of what it would have received had the fraud not occurred. The important part here to really highlight from the statute is that that number, whatever it would be subject to potentially tripling or treble damages, which is certainly a significant level of exposure when you start thinking about the number of dollars that might be involved in any of these circumstances. Different examples that are put forward here, you could imagine in submitting an invoice that includes an allowable cost of $150,000, that's tripled, you're up to $450,000 of exposure. You could imagine in submitting invoices that include an erroneous fee or margin, that entire fee or margin being tripled there. And we're just again talking about the damages component without getting into the penalties. And then, and this is, I think, what the point we're drawing here, Matt will correct me and paper over me if I'm wrong here, but when that last bullet under the example header says award of HubZone set aside contract worth $7 million in revenue, not profits, but in revenue to a company not in compliance with HubZone requirements, there's a position that would be staked potentially by the Department of Justice in measuring the damages that are at issue there of the entirety of the contract. Because the conceit is, well, you weren't going to ever get this HubZone set-aside contract if you didn't actually comply with the HubZone requirements. So that's $7 million in revenue. That's the whole of the contract. That's tripled up to $21 million. And then we start talking about these penalties where it's between this range of 13, give or take, to 27, give or take $1,000 per violation. So just imagine how many different transactions might have gone on inside of a contract worth $7 million where there could have been a false representation or a false claim. And you can get very quickly into astronomical sums. So again, for our purposes, I think the takeaway is there's a real exposure here, and that has to be valued into the kind of compliance and prevention program that you end up constructing.
Yeah, Mark, no, you're spot on, particularly on the HubZone example. The one caveat I will say is that maybe the language used in that bullet is a little too broad, because saying that a company is not in compliance with HubZone requirements, it could mean that there is something less than the entire value of the contract that's in question. For instance, perhaps let's say a company were to move its principal office, and then the contracting officer requests recertification as to size and status at HubZone status at a given point because there's a renewal or something like that. If the contractor was in compliance with the HubZone requirements and was eligible for a HubZone award at the start of the contract, and then they're asked later on to recertify as to size and status, and they are no longer in compliance, and then they certify compliance anyway, that subsequent period of time would probably be the measure of damages. I think the key takeaway here is that the amount of damages that you might face depends on the circumstances and is very fact intensive. The other thing I want to say is to focus on how that we underlined the per violation. In many respects, that means every single invoice that was submitted under a contract where that contract may have been procured because of a misrepresentation in size or status, depending on the circumstances. So if you're submitting an invoice once a month for 5 years, that could be 60 violations if DOJ claims that you were never eligible for the contract in the first place. And when you take 60 times roughly 28,000, I'm not a mathematician, but that's pretty close to $1.8 million right there. You all can correct me in the comments if you are mathematicians, but these violations can add up quickly and be very damaging to a company, and a huge incentive to, when we get to it, implement the procedures on the front end to prevent this kind of stuff from happening to your company.
So how would you have a matter brought to you? There's really two ways that you can imagine it brought forward or taken against your company, or you being under investigation. A government initiated matter would be the first one, maybe not the most typical example, but Matt can speak to that from his experience as well. It could come out of an audit. There's different contract agreements that I'm certain that this audience is familiar with, where you might have an agency who has a right to audit the program or the contract that you're operating under, and they might find something and then want to follow up on that. You could imagine a whistleblower hotline call that goes over to the government, not a suit, but just a whistleblower kind of raising the issue up, and then the government turning its attention to it, and then following up with an investigation. Obviously, the OIGs or the offices of Inspector General might turn their eye towards you, and then the DOJ too. You could imagine as well this spinning off from a different investigation that was connected maybe to a criminal matter, and then this Civil False Claims Act attention being brought your way. There's many, various and sundry ways you could imagine that happening. One of the ways that you don't have to imagine, as I was talking about earlier, it is not infrequent that you might see it come to you in the manner of a qui tam action or qui tam matter. What you have there is, we call them relators, I guess, in the practice. But you have there an individual who has, again, without getting bogged down in the details, information that would be useful to the government and brings forward this suit as kind of a representative or a good citizen to try and recover these funds back into the government. And they end up making that lawsuit filed under seal. It can be years before we end up finding this ends up happening, but they make that filing, and then the Department of Justice has an opportunity to intervene and therefore kind of prosecute hand in hand or arm in arm with this relator who wants to bring it forward, or they have the opportunity to not do that and instead say, you know what, you're going to go forward and decline to litigate with them. There is an entire industry, we don't do that here at this firm, but there is an entire industry of relators counsel who go about their business and try and see whether or not they can solicit individuals who might have this kind of unique information that puts them in a position to be able to bring forward this lawsuit and then ultimately end up going forward and litigating. The thing that is important isn't necessarily the details of how much they end up getting, but it's up to 30% if there's a declined litigation from the DOJ that they could recover from the proceeds of the action or settlement. So when you start talking about things like billions of dollars being recovered by qui tam actions 2.3, if those individuals are getting a third of that, there's a real incentive for people to bring forward, if they have that kind of information that's relevant to the government's investigation of these matters, that information.
I would jump up to the top on the government initiated matter. One thing that I've seen a lot over the last few years is that agencies are filing counterclaims or initiating investigations in response to claims, appeals, and requests for equitable adjustment that may be pursued in the Court of Federal Claims or the Civilian or Armed Services Board of Contract Appeals. So, for example, you might have a construction contract where, as a result of the discovery of differing site conditions, the cost of performing that contract is increased by, say, roughly $3 million. You might file a request for equitable adjustment or a certified claim with the agency saying, you didn't tell us about the soil content below where we were going to build this building. It's substantially different and it's going to cost us $3 million. We want an equitable adjustment to our contract price. And the agency says no for whatever reason. And then a claim is filed in the Board of Contract Appeals or in the Court of Federal Claims. And the government's response to that, the agency says, we have identified fraud in your claim for $3 million. And then that gets referred out to an Office of Inspector General agent or the Department of Justice. And so there are other opportunities for audits or investigations to come from the government, but that is a very frequent or maybe a hot trend, I should say, an unfavorable hot trend that's been happening pretty recently. So I want to talk briefly about, maybe not briefly, about another sort of subtype of FCA matter. And the reason I say it's a subtype is because retaliation claims usually are accompanied by a qui tam action. And these retaliation claims, they are also a whistleblower lawsuit. The government has no standing to raise a retaliation claim on behalf of an employee. So this is the employee or contractor raising it for themselves. They're usually a company insider. Doesn't necessarily mean that they're an employee, but the statute itself says that retaliation against any employee, contractor, or agent is prohibited, and that includes discharge, demotion, suspension, threat, harassment, and here's the kicker, or any other discrimination in terms and conditions of employment because of lawful acts done by the employee, contractor, or agent in furtherance of the FCA. Now, there is some litigation pending about what does it really mean, but when the terms employee, contractor, or agent are used, does it really mean employee relationship or quasi-employment relationship? We don't have a definitive understanding yet from the courts about what that means, but it probably means someone who is close to the company, if they are retaliated against through any number of actions as a result of reporting to the company or to the government a potential violation of the FCA that they reasonably believe to have occurred, then that will trigger a potential violation of the FCA under the retaliation clause and would allow that employee to reinstatement with the same seniority status as if they had never experienced the retaliatory action. Double back pay. So if they are, and keep in mind, these are often supervisor level employees who are theoretically blowing the whistle. So you might be paying someone a couple $100,000 a year, and their retaliation claim may, go on for 3 or 4 years. You could be talking about significant amounts of money in back pay, interest on that back pay, compensation for special damages, which is a little bit of an amorphous category, but I'll give you an example in a few minutes, litigation costs, and attorney's fees. So here's some examples of key TAM matters, what Mark was describing earlier. And we really wanted to highlight the incentive for a whistleblower to blow the whistle. And when I say relator, keep in mind, we're not just talking about an employee, we're not talking about an owner or member of the government, although all of those are possible. We could also be talking about your competitor. That competitor has to materially add to the allegations of fraud that were already in the public. So it's not just that a company won a contract. There needs to be some connection between the information that the whistleblower has and the allegations of fraud, and it needs to be material. But here are some examples. These are all somewhat recent. First, a government contractor last year paid $377 million in settlement to resolve allegations that the contractor improperly billed the government for costs incurred in its non-governmental commercial and international contracts. Essentially, what it was doing was it was incurring indirect costs related to non-governmental work, and it allegedly billed the government, folded those indirect costs into its bills to the government over the course of many years, and eventually settled for $377 million. The whistleblower, who is a former employee, received almost $70 million in fees, the relator fee, plus their attorney's fees. And that suit had been going on for a significant number of years. And you can imagine what the attorney's fees might have been under that circumstance. So we're talking about a $70 million payday. And even though some whistleblowers are encouraged by instant gratification, there's a huge incentive to stay the course on a case like this, because if you think there's a chance you're getting $70 million down the road, it's worth the 5-year, 6-year, even 10-year time that passes while the investigation is going on. This is actually a case, the second example, from about 6 years ago. This was actually the first ever cybersecurity settlement under the FCA. A government contractor paid $8.6 million to resolve allegations that the contractor failed to meet cybersecurity requirements under NIST 800-171 and NIST 853. The whistleblower received $1.72 million. Interesting, plus their attorney's fees. Interestingly, that employee also made a retaliation claim, but the press release that DOJ discussed had to do with the specific settlement with the contractor for $8.6 million and the resulting relator fee. And then pretty recently as well, within the last couple of years, a bank paid $108 million settlement to resolve allegations that the bank violated rules of interest rate reduction and refinance loan programs by overcharging veterans, charging unallowable fees, and falsely certifying compliance with the program. The relator received a 28.5% relator fee, which means that the government did not intervene. Ultimately, it was $30.8 million plus attorney's fees. I believe, if I recall correctly, the attorney's fees were over $1 million. And I included this example because 28.5% is a huge relator fee. Mark said that the cap is 30. He's right about that. The reality, though, is that most relator fees are going to be in the neighborhood of about 20%. So the court awarding 28.5% in this specific case is pretty significant. And frankly, the reason that it was not 30% is because there had been some questionable conduct by the relator's attorneys earlier in the case. And as a sort of punishment, the court dropped it. But this was potentially a 30% relator fee, if not for that weird conduct on the attorney's part. Another couple of examples, these are going to come from the retaliation context. Generally speaking, there aren't any press releases about retaliation, but sometimes it mentions it in passing. So I got to dig into Westlaw and find some of these recent cases. The first one, the employee was allegedly discharged for refusing to create and submit false documents. She ultimately received $127,500 in back pay plus interest, as well as her litigation and attorney's fees costs. And then this next one, I think, is a standout because this employee blew the whistle to internally. There was a merger or acquisition. They recognized that there was an FCA violation, reported it to their supervisor. The supervisor reported it to the government, which resulted in some clawbacks from the government, but nothing too significant. But what ended up happening to the employee was that other employees began harassing and intimidating this individual, and to the point that there was some fear for the employee's safety. And instead of reacting to that and protecting the employee, the employer's response was essentially, maybe you want to leave town. That's the kind of stuff that you want to avoid if at all costs. In the subsequent retaliation claim, the employee received $200,000 in emotional distress damages, and those are awarded as special damages. So there are circumstances where an individual who's suffered emotional distress or even physical illness can recover under the FCA for retaliation. There's $150,000 in back pay, and because of the length of time and effort that went into this case, she also got an award of $1.6 million in attorney's fees and costs. So all that the employer needed to do was regulate its employees to prevent harassment, and they could have avoided this $2 million ultimate penalty damage.
So as we're giving you advice and you're thinking about, well, what does my program look like? What should it look like? It bears mention that the statute of limitations for civil FCA claims is long. You may be familiar that the non-capital federal crimes statute of limitations in the prototypical case is 5 years. So this is longer than that, significantly longer, right? You can see it 6 years from the time the fraud was committed, or 3 years from the time that a government official who's investigating that knew or should have known about the fraud. But in any event, not longer than 10 years. That's a long time for things not to be in repose. So it's something that you need to think about. And obviously the statute of limitations, that bullet at the end there for retaliation, is a little bit narrower. But when we say you need to think about it, I just really highlight that it bears on the kind of record keeping system that you want to build. because if you know that there's a possibility that at some date in the future, you're going to be called upon to explain the behavior and to demonstrate your compliance, or at least your attempt at compliance, because again, it's that state of mind that's so important in delineating between what falls under the potentially punishable and not punishable. I think knowing how long you might be asked to account for is an important data point for you to have, and that's why we're highlighting here the statute of limitations.
Yeah, the one thing I would add is the statute of limitations for retaliation that's in the False Claims Act is 3 years. That was added by an amendment within the last decade or so. But given how long the statute of limitations is in some locations, the prior version of the FCA didn't have a statute of limitations described, and courts, some courts at least, had determined that the statute of limitations for retaliation matches the statute of limitations for the closest cause of action that is similar to an FCA retaliation claim in the state in question. And some states have incredibly long statute of limitations for such behavior. There were a couple of instances where I saw it was either 6 years or 8 years. And so it is possible theoretically that the statute of limitations for retaliation may be a little bit longer in very certain limited circumstances where the cause of action accrued before the amendment to the FCA. But once the amendment came in, from this point forward, it's 3 years.
So here's where I think we turn a little bit more towards the generalized, not specific advice. And hopefully this will be helpful for you. And I understand that we're going to be sending out this material afterwards for everyone too. But how might you protect yourself and your company from FCA claims and investigations? Obviously, the first is to follow the law. That's the easiest way to do it. If you choose to be a contractor with the government, then you want to make sure that you're complying with the requirements and the regulations that attend to contracting with the government. So where can you kind of organize your thinking? The first is to understand the law and what your contracts require. Certainly, I'll say that this webinar is a great place to start in terms of understanding what might be applicable generally, but the more specific requirements are obviously going to be inside of the contracts that you negotiate with the government. So there's a close attention that needs to be paid to the contracts that are negotiated with the government. This is something that myself, Matt, has specific examples, but an attorney in general can help you with. And then understanding too the regulatory and FAR requirements. This would be especially so for anybody who's working with set-aside contracts as one easy and near example. We certainly have a lot of clients who do that. You want to ensure that interplay between those program-specific requirements and the representations that you're making to the government, both with respect to explicit and implicit certifications. So we've talked about that a couple different ways, but bringing it back here again in terms of the generalized advice. Certainly would encourage you to specifically assign duties like paying attention to these requirements to specific employees and ensuring that there is a system in place so there's not a single point of failure. If Jan or Joe is out of the office for the week, it shouldn't be the case that, well, now these invoices go over to the government without the same level of scrutiny. So you want to make sure that you have a robust enough program, depending on the size of your company, certainly, because there is a balance that you have to strike here in terms of risk mitigation and the cost and expense to your company in terms of running a program. But you want to have something that was robust enough to ensure that it wasn't just a single point of failure where one person's oversight and attention to detail or absence would allow something to go through that might end up turning the attention of the United States towards your operations.
If I could jump in, so I want to give like a real life example here. So if any of you are involved in the HubZone program, if you're a government contractor who is awarded HubZone contracts, you know that over the last 5 years or so, the regulations that apply to the HubZone program have adjusted, and in some cases they've become easier to follow, and in some cases they've become more difficult. And so what I recommend when we talk about specific assigned duties to employees, it needs to be someone's responsibility. It needs to be in their job description that they are responsible for understanding at every given moment throughout the year how many HubZone qualified employees a company has, because at various times that number could shift. If you win a new contract and suddenly you have 60 new employees on your payroll, your percentage of HubZone employees is automatically going to change. It might go up, it might go down. It depends on the specific makeup of where those employees are. And you can't just assume that Becky Smith, who was a HubZone employee on January 1st and then moves on March 1st and never updates her address, is still a HubZone employee. You've got to have someone who is responsible for crossing all the T's, dotting all the I's, and making sure that you're responsible for HubZone compliance. The most important time for HubZone compliance is the 4-week period immediately before your annual review. But if you are checking and find out that you're not compliant exactly 4 weeks before your annual review, you're probably not going to be able to bring yourself into compliance if you're missing a couple of employees. So when I say, or Mark says, specified specific assigned duties to employees, someone's got to be on top of that throughout the year to ensure that you don't run afoul of a set-aside program requirement. And obviously the percentages of employees you have to have at given times, whether you do or do not have a HubZone contract, change. And so understanding the requirements of the regulations is important, and then understanding whether you're in compliance at all times is critical.
Thanks. It's obviously, I would agree with him and say that's a great point that leads into the next one. I love the idea of having it in the job description. I can't tell you how uncommon, or how unfortunately common, I should say, it is when we have conversations with clients about who is responsible at this time for compliance, with HubZone as an easy example, but not the only one. And sometimes there's a kind of a casting around of, is it the HR person? Is it the contracts manager? This is something that should be known, and not just known going into that next bullet. It should be something that is written down and recorded in the job description / in the standard operating procedures and internal checklists. I will tell you that it's been my experience overwhelmingly with our clients. People are trying to do the right thing. They're serving their country by being government contractors, and they're aiming, to make a profit, certainly, but at the same time to give back. And yet, if we don't write down what we're doing, we're not demonstrating outwardly to somebody who might come in and look at it 6 years down the road that that's what we were doing. And it just becomes a representation and an impression that you can give them when you're describing things. A standard operating procedure is so much preferable than a set of emails that show, for instance, that we were trying to do this thing at this time and we really took this seriously, or we accomplished this kind of training, or whatever else was onboarding. You can see how the mind races at the examples of things that might show that you are trying to comply and have a standard operating procedure, but aren't the same thing as an internal checklist that's written down, a standard operating procedure that's amended and updated as new contracts or programs come in. So that is something that certainly is a lift, and it's an expense, and it's, in some ways you might feel like it's a distraction, but I think we would generally recommend you to think of that as something that's closely connected to the decision to do business with the government.
Yeah, and I would say those internal checklists, if you're filling them out, and let's stay with the HubZone example. If, let's say, once a month, you're validating your HubZone employees, and on the internal checklist for March, it shows that you've dropped below, let's say that you have an active contract, you drop below 20%, you can immediately take that internal checklist, forward it to HR recruiting, recruit additional HubZone employees, and then on the April checklist, hopefully your number is going to be back up. If you are then faced with an OIG subpoena or a civil investigative demand, which shows or requests documents maintained to show HubZone compliance, you've got all of those internal checklists, which you can show, look, we were keeping track of the number of qualified employees. As soon as we discovered we were in a problem area, we hired more. Here's the proof that we hired more, and here's all of these documentations. There's no FCA violation here, because not only were we keeping ourselves on track as far as our actual qualification period is concerned, we were keeping track of it 12 months a year. Anyway, go ahead.
I think that's well said, and completely agreed again on that point. We've talked in general terms about an idea of an internal audit procedure, so I don't need to belabor that point. But what I would commend to each of you is to consider that if you were going to run the program like we're recommending here, and obviously we're in a position to help you if you need more particularized advice in terms of design. What I would recommend is do something in terms of organizing what you're generating. Matt talked about running a checklist. If you have a checklist and then you just kind of put it in the email and you think, well, now it's an email and we're going to keep the email forever until the heat death of the universe, so we'll be able to find it. Matt talked about a civil investigative demand or a CID where the government might come to you, the OIG. The way that they ask for these things typically, and it's not a criticism, it's just an observation, is they go back very far in time, often to where the statute of limitations have reached back to. So if you have a system in place and you've built it up and it's wonderfully designed and you're executing on it, but the way that you're going to keep it is inside of email and you're trusting things like search terms to generate it out, I can tell you that you could save yourself a lot of time and energy if, as part of your compliance program, you didn't just write down and record what was happening, but you also filed it away in a specific place so that the universe was, in a way, closed, is how I would put it. So we would recommend that. And then obviously establishing a whistleblower policy and hotline is critical. It has a dual effect, right? In the first instance, it allows people to bring forward these things if they feel compelled to do so. And that's obviously well and good. But on the other side, you manifest a willingness to comply and you demonstrate internal to your organization, not for on some date when an investigator is looking at you critically, but in real time, you're telling people who might be skeptical about what's going on or might have a misimpression about what is happening in the company because they've only got so much of a picture and you've got the entire picture of how this company is interfacing with another. Setting up a policy and a hotline and then running through those things and really treating people with respect when they bring forward these claims, even if they're not meritorious, is a way of deterring individuals from going, you know what, I'm not getting heard out here. I don't have a sounding board inside the company. There's no ombudsman who's talking to me about these things. I'm going to go file a lawsuit under seal. Okay, we've talked about this. Matt, anybody who's attended these before, Matt sometimes says, I always say training the trainers. So I'm going to quote Matt from his previous presentations here. It is important to ensure that you're training the trainers and people who are inside your organization who are developing a culture of compliance, you might want to call it. These individuals have some kind of formalized training and that training is documented and it's regularized. Again, we have opportunities if you want to take them when you reach out to us after this webcast and you haven't before, or webinar, I should say. We can walk you through, we can give you examples. We, in different circumstances, have been called upon to present training like that too. But all of this is, one, preventative. It's very helpful to know what the rules are so that you can comply with them. And two, if unfortunately at some point you're called to the carpet to explain why this thing went through, it goes a very long way in showing that this was not reckless. This was not deliberate ignorance or avoidance or indifference, and that there was no actual knowledge. So there's some real value there. And then taking employee complaints seriously. On the last slide, we talked about establishing a system where people could bring it forward in a policy way or inside of a hotline. But certainly it is important when people are having just the normal rank and file type employee dissonance that you might have in a big organization or a small organization where characters are running up against each other, people are becoming frustrated. These things can converge, and it's not infrequent that Matt or I will see a client come in, and then we might suspect that it could be a key TAM action, or maybe we don't know, or maybe we do know, and then ultimately there's going to end up being a constellation of facts that are brought forward to our understanding once the individual who's the relator is identified. And sometimes the clients will say like, oh, well, this was a bad employer, this was a person that we had friction with, or we had problems with. That's not to say that you need to have a jaundice side towards them or you need to be skeptical of them in that way. It's just to let you know that these things converge. In the interest of the organization to ensure that you're doing right by the False Claims Act, the interest of the organization to make sure that you're doing right by the employment standards, these things come together. So the way that you treat employee complaints generally, I think will ultimately be valuable in terms of avoiding the kinds of risks that are attendant to False Claims Act being brought forward. Because even a non-meritorious False Claims Act can be incredibly expensive. Matt and I are experiencing something without identifying it that's incredibly expensive that we would call non-meritorious.
Right. Yeah, and look, I'm not only an FCA lawyer, I'm also a litigator, and I deal with a lot of employment claims that have nothing to do with the FCA. And a lot of employment-related claims come in, usually in the discrimination context, where someone said, or in retaliation under another statute, and they say, I brought this to my supervisor and my supervisor ignored it. Or I brought this to my supervisor and the supervisor, 6 weeks later, I was terminated. And then when I speak to the client or the employer, they say, this person was a problem employee. All they ever did was cry wolf about stuff that is completely irrelevant to their job, or has nothing to do with it. Like for instance, they might say, and I'm giving you a far-fetched example here, that the windows that tinted in the company vehicle are, too dark. And then the second time they come in and they say that the keys on their keyboard stick. And then they say that they don't like where they've been placed in the office because their desk neighbor talks on the phone all day long and it's very annoying. And all of these things are, I'm trying to make them ridiculous for a reason. But they get a little bit closer each time to a real violation. And then that person who's completely blown their credibility out of the water because they complained about the sugar level in the coffee at the break room comes up and says, and by the way, Sally is completely misrepresenting our indirect costs in the accounting department, and you should look into it. By that time, your patience is gone. The employee has no credibility, and you're like, just file it away in this employee's 7-inch thick folder of complaints. Well, if you didn't investigate it, if you didn't take that complaint seriously, that could be the kind of thing that encourages the employee to file a qui tam suit. Or if they end up getting terminated because they've finally come forward with a straw that broke the camel's back, they come forward with a retaliation claim. And one of the reasons I put the training slide or the training words on the same slide as the take employee complaint seriously slide is that they're all sort of intertwined. When we're talking about employees and supervisors who need contract related training and general FCA training, they need to know, specific to your contracts or specific to your business, what is a potential or theoretical violation of the False Claims Act going to look like? Where are our pain points, our vulnerabilities? Where are the contract provisions that we think are outlandish, that we wouldn't normally do? And there are going to be occasional contract related requirements that you're like, this makes no sense. Why would I have to do that? It's important for your people to know that, because just because you think it's outlandish or immaterial, the contracting officer may find it material, and suddenly you're being audited for your failure to submit certain types of documents with your invoices or whatever the case may be. So Mark touched on this a little bit earlier, and I also mentioned it. We want to talk about the paper trail. So as lawyers and litigators in the FCA context, the paper trail is the most important thing. You want to conduct periodic audits of your own systems to ensure that your document retention policies are in place and being followed. The statute of limitations is very long. I'm not telling you that you need to withhold, destruction of documents into perpetuity. The first law firm I ever worked at, we had this room where you would go if you needed a document, and it had boxes going all the way back to 1986 when I was in diapers. But we had it because we didn't want to be placed in a position to have someone ask for a document we didn't have it. You don't have to do that. 6 years is generally recommended in the government for government contractors. And I think that that's a good example for private sector companies as well that are doing business with government contractors. And electronic preservation of documents is fine so long as there's not a single fail point. So if you've got all of your policies or all of your paper trail for a specific contract on one computer or on one flash drive or hard drive, there needs to be a backup point so that if that drive fails, then you have somewhere else to go so that you can back all of this up. The most difficult thing that lawyers do is try to create a timeline or create a narrative for the Department of Justice or from for an officer of Inspector General investigator when there are no documents to back it up, or there are very few documents. And what you end up saying is, I know that I sent the contracting officer this email in 1996 and or 2006, I guess would be a little closer to more reasonable. And but we don't have it. We don't have that email because we changed servers during that time, of course, like everybody else in the entire world. But you could have saved that paper trail, particularly if there are any issues with compliance. If a contracting officer were to say you're not compliant with your compliance with your contract, and you resolve that issue to the contracting officer's satisfaction, you want to keep all of the communications related to that issue in one specific place, protected without a single failure point, so that you could provide that information later on. Same thing with investigations of employee complaints. The other thing I recommend is having a contingency plan. And when I say contingency plan, I actually mean two contingency plans. One that exists at all times, and it may be incorporated into your employee manual or your standard operating procedures. And it basically is, this is what's going to happen when a whistleblower comes in and makes a complaint. And that could be an employee making a complaint, but it also could be that you got a size protest on a contract. You are challenged as a small business for whatever reason. And maybe you win that size protest. You're defending, you're determined to be small, but you still want to implement that contingency plan and to have sort of rules of the road to follow when you're going through potentially adverse actions that affect your company. So you've got this sort of master umbrella contingency plan that tells you what you're going to do. Step 1, step 2, step 3. Step 1 is usually going to be call a lawyer. And again, our contact information will be on the last slide. However, it will include other things like, and we'll get to this on the next slide, stopping destruction of documentation, identifying witnesses, talking to them. All of those are going to apply across the board to what we call catastrophic acts or catastrophic events. But then you're also going to create a contingency plan for independent complaints or independent events. Let's say that you receive an OIG investigation, a subpoena of some sort, or an employee is approached by an OIG investigator outside of the context of the company, like at their home. The company has no knowledge of it, but then the employee comes in on Monday morning and says, hey, by the way, a US Marshal showed up at my house and was asking questions about this contract. That's when you create the contingency plan for that specific adverse event. You figure out, it requires you to start thinking about what could have led to this conversation. Why is this an investigation? What is it about this specific contract or this specific series of events? Who should I talk to? You want to have a contingency plan that fits not only for the broad adverse event that might happen at any time in the company, but then make it more detailed and apply it in individual circumstances. So you want to implement corrective action where necessary. So let's say that an employee comes to you and says, I was on the proposal team for such and such contract, and I remember us bidding a 4% fee. But I was just running through the numbers with the accountant, and I think we're charging a 5% fee on this contract. You got to investigate that. Even if you think there's no way that the employee is right, you still investigate. And if you find out that there is a mistake, like there's a single invoice where you copied and pasted the wrong information, you take corrective action. You would notify the government and say, we've overbilled you. Here is what we've done. Here's the documentation that shows what we did. And you want to maintain that documentation to show that if the government comes after you later or a whistleblower comes after you later, you can prove that you did take corrective action to solve the problem. You want to perform any necessary audit or internal investigation. These go hand in hand. You want to make sure you're asking the right witnesses who have the information, what happened, and you're taking the appropriate review of documents to make sure that it doesn't happen again. There are mandatory disclosure requirements when you discover an FCA violation. Sometimes this happens, particularly in M&A transactions, where a company purchases a small business and it doesn't come out in due diligence, but shortly afterwards you discover that they billed a number of contracts incorrectly, or they weren't in compliance with certain cybersecurity requirements, something like that. Technically, you're required to disclose that to the government. That may not get you out of the penalties associated with an FCA violation that you have discovered, but it is going to buy you goodwill with the government. The government, in its discretion, may choose not to come after you at all. They may go after the prior, the seller, essentially. And there is a cooperation credits, which the Department of Justice will issue. You could actually reduce the amount of damages overall that you may be claimed to have owed. And sometimes it goes all the way down to 2 times the amount of the actual damages as opposed to 3 times. And then this is one thing that is always difficult for employers, but you need to take employee discipline, restructuring, and or retraining obligations seriously. When there is an FCA violation that is caught and cured, sometimes 6 months down the road, we get a complaint from the government and they say, you haven't done anything about this violation. And it's not because the company didn't actually do something. They actually did behind the scenes, but they never took any discipline or retrained the employee, and the employee might be still violating the FCA. So you've got to cover your bases top to bottom. So when you are faced with an FCA matter, there are a few ways you might get notice. You might get a grand jury subpoena. We've talked a little bit about civil investigative demands, OIG subpoenas. You might even get a search warrant. The first thing I can say is don't panic. I know it's a very disruptive thing to have a U.S. Marshal or an OIG investigator show up at the front door of your house or at the business, but you cannot lose your sense of self in the moment. You want to obtain knowledgeable counsel with experience in the subject matter. I wouldn't necessarily put that first. The first thing I would say is don't talk to the government without counsel, all the way at the bottom. If they have shown up with a search warrant, which happens very, very rarely, but sometimes when they're trying to intimidate a company or a person, they show up with a search warrant. You want to see it, you want to check to make sure it's signed, and you want to make sure that they have authorization to search your office or wherever they show up. There have been instances where a search warrant has given authorization to search a person's house, and they have shown up at their office, and the search warrant did not give authorization to search the office. If they don't have a search warrant and you don't consent, they cannot search. Barring exigent circumstances, we're not going to get into a constitutional debate here, but generally speaking, if they're showing up with a search warrant in a corporate capacity, they don't have exigent circumstances unless they think that you are about to destroy all of the documents. The best way to respond to someone who shows up on your door is to say, thank you for coming to see me. Can I have your card? I will give it to my lawyer, and my lawyer will set up a time for us to talk. There have been a number of times in my career where an employee or an individual calls me and says, the U.S. Marshals just left. I gave them I talked to them for 2 hours at my kitchen table over coffee. They seemed really nice. The government is not on your side in an FCA investigation. Even if you haven't done anything wrong, the government is not on your side. So don't talk to them. Be polite. Don't try and immediately kick them off of your property. But what you can say is, I'm not willing to talk to you without counsel. I would be happy to schedule a meeting or an interview once my counsel is involved. I'll take your card and I'll get them involved. And obviously implement your contingency plan as well.
And this is our last substantive slide. I know we've got one question in the queue, so if anybody's holding on to questions, you can start putting them in there. Just to round out some of the points that Matt's made along the way, and I have as well. Certainly, when faced with this matter, you would stop the routine email or document destruction. You want to archive that material and make sure that it's not going to be disturbed. This is, again, of a kind with what we were talking about before, and having a process in place so as not to lose these things. It becomes suspect. It just does, because the surrounding context of losing material matters for the people who are judging why that material is missing and what kind of inferences can be drawn now that we don't have the material anymore. And things that are lost after you've been put on notice are concerning for a finder of fact. They're concerning for the government in negotiating a settlement as well. So certainly don't lose anything once you're under investigation. And like we've talked about before, you shouldn't be losing it along the way unless you install a plan and it's on a regular process and procedure that you do that. Internal investigations we've talked about as well. This has a little bit more detail on it, and it raises, I think, a significant point. There's a manner and a mode of conducting an internal investigation when you involve attorneys like ourselves or other attorneys or even potentially in-house counsel involved in that process, where you can put under this umbrella of attorney-client privilege a lot of the material that would be otherwise generated as potentially available to investigators. So it's probably a longer, maybe an hour or two long conversation to get into all the nuances of it. But one of the things that we would recommend to you to at least consider at the outset of an investigation is talk to an attorney and see whether or not they have an opportunity to assist you in that process and to give you that safeguard, that additional protection from wandering eyes, perhaps, of what the findings are inside of that investigation. There's real value in any circumstance in recording a knowledgeable witness's understanding before they're lost to time. So that's why we're encouraging you to interview witnesses early. And then certainly you'd want to, as you're going across and interviewing individuals and you're collecting information, you'd be remiss not to remind those individuals that we don't have any kind of retaliation that goes on in this company. We have policies against discrimination, because you don't want to be in a situation where you're running an investigation, you're doing the right thing, but you're also signaling to people that there's a relator, for instance, who's brought forward a claim, and that person is retaliated against with an adverse action, and you just compounded the allegations set against you. I think we've hit verifying your paper trail along the way and documenting what you've generated. So these are some good questions to ask yourself in terms of testing it, and then document.
So that wraps us up for today. Our contact information is up there on the slide, and we're happy to follow up with specific questions you may have. We do have one question from the audience, and I'll read it. I think I'm probably going to defer you to shoot us an email afterwards, because it's a little bit of a nuanced question. But the question is, what happens if you are receiving a sole source award under a NAICS code that a prior company had, but they've graduated from that as their primary NAICS code? So there's a lot of really nuanced government contracting issues being addressed there. I'm going to generalize it to sort of fit with the topic we've been talking about. So the most important thing is to understand when we talk about graduating from a primary NAICS code, that can implement whether you're a small business, whether you're still qualified as an 8A, whether you're eligible for the contract award in the first place. So that all factors into sort of knowing the law and knowing your contracts and the details of how you can comply. There are certainly instances where a company may no longer be large, or they may not be a member of the socioeconomic set-aside group, but they may still be eligible for a contract under certain circumstances, such as if it's a task order under a multiple award contract that was issued at the time when the company was eligible. But you need to know all of that in some way, shape, or form in order to know whether you're eligible to bid on a contract or a task order. And so you need to understand, particularly for small business and set-aside issues, you need to be constantly aware of your size, constantly aware of your status, and constantly aware of the provisions of your specific contract and whether the contracting officer is requesting recertification as to size or status on a multiple award contract, because all of those factors are going to determine whether you're ultimately eligible. But for whoever asked that question, I think it's probably better to shoot us an email, and we'd be happy to talk through the specific circumstances, because otherwise we can probably do an entire webinar just based on this question. Nothing else is coming in as far as questions or concerns. We hope you've enjoyed today's webinar as well as the first and second iteration of this 3-part series. We will be happy to answer any questions you may have, and I hope we see you on a future webinar on the FCA or another topic sometime soon. Thanks everybody, and enjoy your afternoon.